This is Kirby Glad, a professional registered parliamentarian, and here is a little overview of Robert's rules on the disciplinary process. So this is not meant to be an exhaustive discussion of the process for discipline. It won't go into a lot of detail about the trial, but it's meant to hit the highlights and just kind of discuss the general principles involved. It'll be important to understand the difference between a government and a private association, which thereby gives us a difference between the legal concepts of a court action or a government action and the disciplinary concepts of a private association. And then we'll just quickly review from a high level the disciplinary process. So here's something that's important to remember between the government and a private association. We think about the Constitution as being the Constitution of the United States. Then we also have a Constitution for our own association, and it's easy to kind of get the two confused. But here are some very important things to remember. First of all, the government is an involuntary organization. If you're a foreigner and you come to America, there's no box where you check to say, do you want to be subject to the laws of the United States or not? If you move from one state to another, you don't have the option of continuing to observe the laws in the previous state. You have to observe the laws of the state that you're in. You're subject to those laws. The government was created years ago by the people, for the people, and that means that you, the people, are subject to the government. Whereas a private association is strictly voluntary. You can choose to become a member of an association, you can choose to leave an association, and the association can choose to leave you. You have no right to be a member of any organization. That organization, whether it's a church that wants to excommunicate you, or a political party that wants to remove you from your party office, or the Rotary Club, or the Kennel Club, they can all choose who the members should be. So your only way to avoid being subject to the government is to leave the jurisdiction, whether it's a city or a state or a nation. As long as you're within that jurisdiction, you are subject to the laws of the government. But you can leave an association anytime by simply discontinuing your membership. The purpose of the government is to protect individuals. So the federal government exists to protect us from other countries, from other armies that might want to invade us. Our local government is to protect us from criminals who might want to harm us. The purpose of the government is to create an environment for commerce where commerce can be protected. The purpose of the government is to protect people from danger or starvation or however you want to think of it. But the private association has no loyalty to individuals. Its only concern is the effectiveness of the association. Each association has certain objectives that it wants to obtain, and its only job is to pursue those the effectiveness of those objectives, regardless of persons. So there's no responsibility to protect people in a private association. A government has only enumerated powers. So, and we're talking about the United States Constitution. When we created the federal government and the state governments, we gave as the people to those governments only the powers that we specifically give them. Okay? But a private association is all powerful. So if I get with my buddy John and we create uh, the unicorn support group, unicorn fan group, what can we do? We start a club, he and I. What can we do? We can do anything. We can do anything that is allowed by the laws of our government. So if we decide that our group starts to get bigger, then we need rules to decide how to do things. How we would limit ourselves by creating a constitution and bylaws. So in an association, uh, the association is all powerful and is only limited by what rules it chooses to give itself, whereas the government is limited to specifically enumerated powers. Now, the government can do all kinds of bad things to us. The government can take away our stuff and it can kill us. It has complete and control over us, and so we need a lot of protections from the government. The worst thing a private association can do to us is kick us out. And so we have very little protection against a private association. We have a lot of rights that protect us from the government. In fact, when we gave the government its enumerated powers, we also described specific constitutional rights, things that the government may not do to us. In a private association, we only have parliamentary rights. We don't have constitutional rights. Those don't apply. In the government, we have separation of powers because we don't want the government to be too effective. Since the government has the ability to take our stuff and kill us, we want it to really not function at its peak effectiveness. So we separate powers. We give a legislative branch, and we have a judicial branch, and we have an executive branch, so that the government can't really be too effective. However, in a private association, we want the government of the association to be completely effective. And so everything, all the powers, is combined and belongs to the association, the assembly, the body. There is no such thing as an executive branch. There's no such thing as a judicial branch. There's no such thing as a legislative branch. The assembly is all judge, executioner, and lawmaker. But the assembly can delegate powers which are too tedious to exercise in a large group. So it may form a committee to be a judicial committee in some cases. It may form an executive committee to handle its day-to-day business. It may form other committees to advise it on its bylaws or other things, or to even pass rules subject to the approval of the assembly. But the assembly has all power to withdraw these delegations at any time, unlike the separated powers in the Constitution, where the legislature cannot say, for example, we're tired of having the executive branch, and we're just going to do away with that, and we'll do both for now. They can't do that because they only have the powers given to them in the Constitution. But an assembly can eliminate any of these branches or delegations at any time and bring that power back into itself. It's completely autonomous, and it only delegates the powers that are necessary for it efficiently. So within the Constitution, we have certain constitutional rights, and the rights protect us from the government. Constitutional rights do not protect us from each other or from associations. They're only applicable between us and the government. Some examples are the right to free speech, the right to protection from self-incrimination, the Fifth Amendment. In the Fifth Amendment, if you invoke your Fifth Amendment right, then the judge or the jury is not allowed to hold that against you because that is your right. There's a right to due process within our Constitution. There's a right to be convicted by a jury of our peers beyond a reasonable doubt. These are all constitutional rights which protect you from the government. We have civil rights which protect us from civilians. Okay, as a civilian of the United States, you have these rights: the rights to have not be discriminated against based upon the color of your skin or your national origin or your religion or other areas which we deem to be areas of protection. You have the right to your property. No one can take your property away from you, like a robber or a thief. That is a violation of your rights, and there are laws to protect you against that. No one can take your life away. Other people are not allowed to kill you. The government can kill you based upon their process, but other people are not allowed to kill you. Now, you also have parliamentary rights. Parliamentary rights are protection from the supermajority. The rights such as the ability to debate and make motions, those can all be taken away from you by a two-thirds vote. That's the supermajority. So even though members of our organization have the right to speak, or the right to change the agenda, or the right to whatever they want, they only can continue those rights so long as a two-thirds vote doesn't preclude them. So a two-thirds vote can end debate. A two-thirds vote can change, set rules. A two-thirds vote can do all kinds of things. But there are certain things that even a two-thirds vote cannot do. That is, they cannot deprive a member of notice of meetings. If there's a meeting of your assembly, you're entitled to a notice of it, and no vote of even 90% can remove your right for that. The right to vote cannot be infringed even by a supermajority of an assembly unless you're removed from the organization. And you have the right to participate in meetings, which to listen, and while debate is open, to participate on equal footing with everyone else. Remember that in an association, constitutional rights do not apply. In your organization, you do not have the right of free speech. You do not have the right of protection from self-discrimination. You do not even have a right of due process. Although, as an organization, you may wish to extend those privileges, you do not have these rights. Those are protections from the government, not protections from your association. So this leads then to some logical differences between the concepts between legal procedures and disciplinary concepts under Robert's rules. So under legal procedure, it's adversarial. Remember, the government's duty is to protect you from other people. So if you feel someone else is hurting you, you file a complaint against that person and you are the complainant and they are the defendant. If someone injures you, you go to the police and they will file a legal action as the jurisdiction or the people of their city or the people of the United States against that person because they have violated the laws of the land. However, under the disciplinary process of an organization, we're only worried about the good of the association. We only want to take under our disciplinary process things that damage the association. We don't care if you offended someone. We don't care if one person did something against another person. That's not our problem. We're not an adversarial. We're not here to protect you. We're only here for the good of the association. And so our disciplinary process is focused around what protects the association. We have, under the legal process, rules of evidence. In other words, only certain things are permissible, certain things which are deemed to be legal. We can't have things that are based upon illegal search and seizure. You have to be read your rights. Certain statements are not in evidence because they may be hearsay. Under our private association, we don't care about any of that. We will consider any evidence, no matter how flimsy, but we will consider it. It's under consideration. So if there's circumstantial evidence, we can determine the strength of it. If there's hearsay evidence, we can determine how much to believe in it or not. Under the legal process, there's reasonable doubt or preponderance of the evidence, which is how decisions are made. If you're found guilty in a court of criminal law, it must be based upon beyond reasonable doubt. If you're to be found culpable under civil law, it must be based on the preponderance of the evidence. We don't have any of those standards in our association. Well, our only standard is that the people who are making the decision must be morally convinced that the person is guilty or innocent. So it's purely based upon the people who are making the decision, whether they feel that this person has truly damaged the organization or not. Under the legal process, we have a prima facie case or prima facie case, depending on how you pronounce the Latin. That means that the government or a person making a lawsuit cannot proceed until they have the basic case necessary to hold up. In other words, a prima facie case means, in the case of a criminal trial, without rebuttal, does the government have enough evidence to show that a crime was committed and then this person committed it without any defense? So in other words, a case that stands on its own. And if the government does not have that, then they're not allowed to proceed. In a civil suit, legally, and I'm not an attorney, but I know how to read, a company that wants to sue or a person that wants to sue another person must show that they have enough evidence to proceed, or the case is dismissed. Okay. However, in a disciplinary process, we're only looking for, does the issue have substance? Now, I'm not going to define substance for you. It's kind of a vague term, but it may depend on organization to organization. But different organizations use the same word in different ways. Like the complaint is substantiated, means it has substance, or there is some evidence. So, but one way of looking at substance is there any reason to believe that the complaint is true? And if it's true, would it uh, should it actually result in some disciplinary action? Did it harm the organization in some way? And all we're trying to determine at this preliminary stage is there something to it, or is it nothing? Is it flimsy or not provable? Under the legal process, there's a prescribed sentence. So if you violate the rule against armed robbery, then then the statute says if you commit this crime, you'll go to jail for 10 to 15 years, whatever it is, or you'll pay a fine, whatever it is. There's a prescribed sentence in the legal procedure. In the disciplinary process, there's very seldom a prescribed sentence. Usually the sentence is described as being anything up to and including removal from office or removal as a membership from the association. So the discretionary sentence can be nothing. So it's totally possible for the body that's determining the disposition of a complaint or a disciplinary issue to say, you know what, this person is guilty of sin and the punishment shall be nothing. Or it could be a verbal reprimand, a written reprimand. It could be a strongly worded letter. It could be a lecture from the chair. It could be a suspension from office in some cases. It could be removal from office in some cases. It could be removal from membership in some cases, if the governing documents of the body allow this. But there is no prescribed sentence unless they're specifically stated in the governing documents of the body. If you do this, then this is what will happen. In a legal process, of course, you are protected by your constitutional and civil rights. But in the disciplinary process, you have no constitutional rights. You have only parliamentary rights, as we have described before. So here's the basic overview then of the Roberts Rules newly revised disciplinary process. First, there's an initiation of some sort of disciplinary action. And for this, I'm talking about actions outside of a meeting. Actions inside of a meeting have their own remedy inside the meeting. So if someone is out of order, that can be handled inside a meeting. If the chair makes a ruling which is not following Robert's rules, that can be handled inside of a meeting. If the assembly does something that is against the bylaws, that can be handled inside of a meeting. There's processes for all of these things to be done inside of a meeting. So the only time we need disciplinary process is for things that are done outside of a meeting. So the way this is handled is there's an initiation of the disciplinary process. This could mean that there are a couple ways of initiating the process. When any member believes that someone has done something which would injure the society, that person can bring a motion in an executive session to create an investigatory committee. In some organizations, the investigation committee is a standing committee. It may be called a variety of things. It may be called discipline committee or the ethics committee or the investigating committee, or it may not even be called that. In some organizations, maybe there's another committee like the executive committee that's tasked with investigations. But in any event, if there's no process described in the governing documents, the disciplinary process is initiated by a motion made to start investigation. However, the next step, however that is done according to the organization, the next step is to proceed with the investigation and attempted resolution. So Roberts says that the purpose of the investigation is to try and resolve the matter before it has to go to a hearing. So investigation means contacting the person who is accused of harming the society and finding out what's your story, seeing if they'll cooperate, and maybe there's a way to resolve it without even pursuing the matter. So Maybe there's something that they can undo, or in many cases, I've seen just, are you willing to call so and so and apologize? And sometimes that's all it takes. But the investigation committee is to see if they can get some kind of a resolution, or see if the complaint has any substance. Now, in a complaint, there's very seldom, or there are some cases, I shouldn't say very seldom, there's some cases where there's no real evidence. Maybe all you have is somebody's word or hearsay. Somebody told me that this person did this. And is that admissible in a disciplinary hearing? Yeah, of course it is, because remember, we don't have the standards of evidence, but it is up to you to consider how convincing that argument is. So if I say, well, I saw Lizzie Proctor dancing with the devil, then, as an investigation committee, you can say, well, when was that? Or what did you do? Or what did she see? And then if I contact Lizzie Proctor and Lizzie Proctor says, I never did that, I don't know what you're talking about, then you don't have to necessarily bring that complaint to forward to a hearing. It may be that the investigating committee just looks at the testimony of both sides or the hearsay evidence and just says, you know what, we just don't believe it. And even if it was true, or even if it was true, we don't have any rules against that. We allow our members to dance with the devil if they prefer. So in the investigation, you're looking for any evidence of something that was actually done, and what violation, if any, would that be, either of the bylaws or basic ethics or laws. So what would be ethics violations? Or what would be a disciplinary violation? In Roberts is kind of defined as dereliction of duty, or misappropriate. I mean, obviously stealing money from the organization, that would be a big one. If the chair of your political party is caught on videotape in a hot tub naked with underage boys, that would certainly be an example. There might be other minor ones, but you're really looking for a standard that is going to harm the organization. It may be even activities unbecoming a member of our organization. If you're a church, for example, and someone is caught with a prostitute, and maybe maybe it's a high person in the church, well, then you would probably remove them from your church based upon conduct unbecoming a member of the church. So this kind of process is a private organization process, and whatever your standards are as an organization, that is what you're using to determine if a harm was done and if the allegations have any substance to them. What you're trying to come up with is charges and specifications. So the output of the investigation should be charges and specifications. So a specification is a very specific thing that the person did. For example, a specification that on June 4th of 2017, the subject wrote an email to a reporter by the name of John Smith, who made defaming comments about the society to the reporter. Okay, that is an example of a specification. It's very specific. That's why it's called a specification. What exactly did the person do? When was it? Where was it? And then something that can be proved. Okay, and maybe it can be only barely proved by hearsay, or maybe it can be strongly proved by having a copy of the email. But it needs to be something that there's some evidence for. Then the charge is, well, if the person did the specification, if the person actually performed that deed, then how is that injurious to the group? So, for example, a charge may be that the subject was a derelict in their duty because the specification then would be on such and such a date, the individual failed to file the income tax return, which is their constitutional duty. And this resulted in a late penalty of $1 million to the organization, whatever. So charges and specification. The charge is what is the reason or the cause of action, whether it's a bylaw that was violated that says if you violate this bylaw, then you're removed from office, or whatever is the charge. And then the specification is the specific act that created the charge. So charges and specifications then are brought to a trial. And again, the purpose of this training is not to describe in detail the trial process, but the charges and specifications are read at trial. The person who is accused is then given the opportunity to enter a plea. And the plea can either be, no, I did not do that specification, that's not real, that didn't actually happen. Or the plea can be, yes, I did it, but that doesn't support the charge. Yes, I failed to file the tax return, but that does not support a charge of dereliction of duty. It's simply a minor error, and I paid the fee, and it was only $40, so that doesn't really constitute dereliction of duty. So there are two defenses. One is the specification is untrue, and the second one is the specification does not support the charge. So the person may plead guilty to the specification, that yes, I did that, but not guilty to the charge. And there might be a whole variety of different specifications and different charges, and each one's handled individually. Then, once we decide which ones, of course, if a person pleads guilty to a charge, then you skip right to the determination of the penalty. If they plead not guilty, then we have a hearing of evidence, and the evidence may be quite flimsy. It may be quite substantial. It just depends on what the investigation committee brings forward. And again, if the investigation committee doesn't believe any of it, then they would probably find that there's no substance to the matter. If they believe there is substance to the matter, then it's the job of the investigation committee to present the evidence to whatever organization does the trial, whether it's the assembly itself could do the trial, or sometimes there's a committee appointed to do trials. It just depends on the governing documents of the organization. Then, after the evidence is presented and the person who's accused has an opportunity to make their own presentation of evidence and rebuttal. Again, there's a process for that, which I'm not going into detail. Then there's a vote on determination of guilt for each of the charges. So if there's 4 different charges, then the people who are in the trial committee or whoever is performing the trial will be able to vote guilty or not guilty on each of the 4 different charges, or 1 or 3 or however many they are. Then if there's not a majority vote that the person is guilty on a charge, then that's the end of it. If the majority vote is that there is a guilt of the person of a charge, then you enter the determination of the penalty phase. And there, someone makes a motion and says, well, I believe that because this individual was found guilty of the charge of dancing with the devil, that the penalty should be blank. The penalty should be a strongly worded letter be sent to the individual, encouraging them to stop dancing with the devil. And then someone could amend that to say, no, I think it should be removal from office or this or that. And you just use the standard parliamentary process to craft a motion, and then you vote on it. And then let's say that there's a motion for let's have the person be removed from office, and then we vote on it and it's rejected. Well, then we still haven't determined the penalty yet, so someone else makes another motion for a penalty. How about a verbal reprimand? Okay, great. Then we vote on that, and then it's approved. So we all agree by majority vote that that is the penalty, and that's it. Okay. To remove from office, unless the governing documents say something otherwise, requires a 2/3 vote. So then, once we determine the penalty, we inform the accused. The accused is not present during the determination of guilt or the determination of penalty. So we bring the person back in the room, or we send them an email, call them on the phone, and say, just informing you that The assembly or the trial committee or whoever is the body responsible has determined that you are guilty of this charge, and we have assessed this penalty upon you. You have to spend 1 day in the stockades, or there's a fine of $100, which of course would be voluntary, or I'm going to read you this strongly worded letter, or you've been removed from office, whatever it is. In a very few cases, there's also some public information. If, for example, a person is removed from office, then you may find it necessary to just make an announcement. This person is no longer serving as the treasurer of our society. That's all. You just need to make people aware of that. Or this person will no longer be serving as the chair. That's fine. You don't have to say why or the person was removed. You want to give as little information as necessary just to inform the public of who is acting in the name of the organization. So that is the final disposition. So whatever is determined as the determination of guilt and the determination of the penalty, that's the final decision, or and some documents call it consideration, some call it disposition, some call it other words, but it's basically meant to say that whatever is going to be happening, the final result is determined. In some cases, there is an opportunity for appeal. Often, if there is a committee that's given the task of hearing discipline issues and determining whether someone should be removed or not or whatever, oftentimes there is an appeal to the larger assembly. Um, and whatever's in the governing documents, that would be observed and followed. Generally, an appeal either approves the action that's taken by the hearing committee or rejects it. So there's no, usually speaking, depending on what the documents say, if someone's removed from office, you don't go to the appeal and then they change that to a strongly worded letter. Usually they just either confirm it or they don't uphold the appeal. So anyway, as I said, this is not intended to be an exhaustive discussion of the. This is not meant. I'm sorry, a little choppy there. This is not to be an exhaustive discussion of the process, only an overview. And if we then to summarize, discipline in an organization should really be used very sparingly. It's for the good of society in cases where the society is being harmed. It's not for the purpose of resolving disputes between members. So, for example, in the slide I just had, you notice there's no step where we inform the person who made the complaint. There's no victim's rights. There's no, okay, I'm going to withdraw my complaint. The complaint is about the society. So it's not in the hands of an individual. It's simply the individual brings to the attention of the society something that's damaging to the society. So the person who brings the complaint has no particular rights in the matter. We're not trying to resolve, someone injured someone else. That's not what we're talking about. We don't care about that. We are only worried about the society. So if someone's damaging the society, we want them out, or we want them to stop doing it. We want to repair the process, but we're not here to try and resolve who's injuring someone else. If you'd like additional training on the trial process or any questions about any of the issues brought up in this training, please contact me, Kirby@parliamentarian.com. Thanks, and that concludes this presentation.